Hey everyone. Thanks for coming out tonight. My name is Erica Stolniker, and I'm president of the Duke Law Chapter of the Federalist Society. Our guest this evening is Douglas Fife. Mr. Fife is a senior fellow and director of the Center of National Security Strategies at the Hudson Institute. He also is a visiting scholar at Harvard University's Kennedy School of Government. He is the author of War and Decision, Inside the Pentagon at the Dawn of the War on Terrorism, and all earnings and royalties from the book go to charities caring for our men and women in uniform. He was Undersecretary of Defense for Policy from July 2001 until August 2005. In this capacity, he helped develop the U.S. strategy for the war on terror and contributed to policymaking for both the Afghanistan and Iraq campaigns. His duties included managing the Defense Department's international relations and representing the department in interagency policymaking. He also advised President Bush and Secretary of Defense Rumsfeld on a range of national security issues, including the nuclear programs of North Korea and Iran, the counterinsurgency in Colombia, and the Palestinian-Israeli peace diplomacy. Mr. Fife also worked at the White House as a Middle East specialist for the National Security Council and then as Deputy Assistant Secretary of Defense for Negotiations Policy in the Reagan administration. After each of his Pentagon tours, Mr. Fife received the Distinguished Public Service Medal, the Defense Department's highest civilian award. Mr. Fife holds a JD from Georgetown and an AB from Harvard. Please join me in welcoming him.
Thank you. Thank you, Erica. It's very nice to have this chance to meet with you, and I appreciate Duke's Federalist Society and the American Grand Strategy Program and the Duke American Constitution Society for, thank you for sponsoring this. Now, many, perhaps most of you are law students. I assume that a number of you may want to work someday in the federal government. I'd be curious, by the way, who here has an interest in working in the federal government? Okay, that's a substantial number. Well, especially for those of you interested in such work, I'd encourage you, as I review some of the recent history, to ask yourself how you would have handled the issues that I'm going to talk about if you were in my job, or if you were a legal advisor to the Secretary of Defense when the 9/11 attack occurred. I assume that most of you are somewhere around 22, 23 years old, which means that you were 13 or 14 when the 9/11 attack happened. And so you've probably kept pretty vivid memories of that day. And I would urge you to try to recall the frame of mind that you had and that the people around you had after the attack. I find that it seems to be fading quickly into almost ancient history. And I think if you want to understand the kinds of things that I hope we can discuss here, some of the key decisions that were made after 9/11, some of the important trade-offs that were made after 9/11, it's useful to try to retrieve the frame of mind that was prevalent throughout the country after that attack. Now, I had just moved from my private law practice into my job as Undersecretary of Defense for Policy in mid-July 2001. And on 9/11, I was in Moscow. We were talking with the Russians about missile defense and arms control issues, some of the same things that are currently being discussed by the Obama administration. On September 12th, I flew back to Washington on a military aircraft with several Defense Department colleagues, one of whom was Peter Rodman, who very unfortunately died recently at a very young age. Peter was a thoughtful, an erudite, Harvard Law educated Assistant Secretary of Defense for International Security Affairs. And while crossing the Atlantic Ocean, Peter and I spent hours discussing how to understand the nature of the threat posed by the people who had attacked New York and Washington, and how to strategize the U.S. response. With some other people on the plane, we discussed various actions: shutting down civilian air traffic over the United States, clamping down on port security, increasing inspections of travelers, increasing security for all kinds of facilities, public and private, in the United States. And we discussed the dangers to our society if follow-on attacks to the 9/11 attack were to occur. Now, these dangers went well beyond the risk to American lives and property. What we discussed was, if there were to be a series of 9/11 type attacks, there would be a clamor in the country for tighter security, for more restrictions on travel, for more intrusive inspections, demands for ethnic profiling. Our discussion quickly led us to some fundamental questions about our essential responsibilities as national security officials of the United States. We discussed with each other that as we considered proposals for fighting our terrorist enemies, we have to keep in mind what it is that U.S. national security officials have taken an oath to secure. In the United States, national security refers to more than protecting territory or people. The United States is not just a country, it's a country that lives in a certain way. The word American doesn't proclaim an ethnic identity, but an association with a community regulated by the Constitution, which is why, though one cannot instantly change one's ethnicity, millions of people have, by taking an oath, become not just American citizens, but Americans. All of this is to say that civil liberties are not just a feature of life here, they're what define us as a nation. And the civil liberties of the American people, therefore, are what we aim to secure when we work on national security policy. Now, part of my college education was reading John Stuart Mill, who championed the ethical and practical benefits of liberal principles, principles that respect the worth of individuals and their equality under the law. And in his writings, including his 1859 essay on liberty, Mill argued that humane and sensible societies allow their people as much individual freedom as is consistent with what he called self-protection or public safety. Much of what makes Americans happy, their political freedom, economic prosperity, domestic tranquility, and opportunity to better themselves, derives from the liberal and democratic nature of our society and the degree of mutual trust, which is sometimes referred to as social capital, that such a society engenders. It is hard to overstate the moral and material benefits that are rooted in that social capital, in that trust, in our freedom. And this we saw, and this was actually the topic of conversation that Peter Rodman and I and some other colleagues had on this airplane. This is what was at stake in the war on terrorism. Beyond the cost in lives and property, the 9/11 attack, or rather our reaction to it, would expose a far-reaching element of the threat posed by terrorism. To protect ourselves physically, we might feel compelled to change fundamentally the way we live, sacrificing our society's openness for hoped-for safety. Because of our good fortune throughout history, we Americans enjoyed for a long time a high degree of public safety, and so became accustomed to thinking that the liberal openness of our way of life is not only sacred, but immutable. But a community's freedom depends on circumstances. Societies inevitably adjust to allow the state to fulfill its most basic duty, which is providing security. As noted, even such uncompromising champions of liberty as John Stuart Mill bow to the exigencies of public safety. Our Constitution and the judges that interpret it often seem to be saying that our freedoms are absolute, but history shows that when danger becomes oppressive, people are wont to recall the quip that I'm sure a lot of you have heard, that the Constitution is not a suicide pact. In the immediate aftermath of 9/11, concerned that another attack might be in the works, our government took actions to eliminate vulnerabilities that the hijackers had turned to their advantage. As I mentioned, we shut down air travel throughout the United States, and when it resumed, we intensified airport security measures, and as you know, folks now have to walk shoeless and beltless and uncoated through time-consuming airport security lines whenever they want to fly. At the same time, the government restricted the issuance of visas, thus affecting not only the freedom of foreigners to travel, but the freedom of Americans to host them. And new legislation allowed intelligence and law enforcement agencies to share information more readily. These were steps deemed prudent, indeed necessary, in the light of what we knew and what we didn't know at the time. Now, my interest here is not so much to defend every specific measure taken by Congress and the administration. Rather, it's to stress that beyond the human and material costs it imposes, terrorism takes advantage of and thereby endangers the openness and trust that allow us to enjoy freedom and prosperity. If another 9/11 happened, especially an attack involving chemical or biological or nuclear weapons, who could doubt that our society would respond by increasing further the powers of government affecting our freedoms? As has happened over and over again for the last 40 years or so, since the era of airplane hijacking got into full swing, security measures that once seemed outrageous could, over time, become routine. Thoughts like this weighed on President Bush and his advisors as they considered, in the period immediately after the attack, how to prevent the next attack against the United States. If the strategy for preventing that attack were to be solely or even primarily defensive, it would require a wholesale clamping down, not just at our borders, but throughout the country. President Bush early on decided that 9/11 was an act of war, not merely a law enforcement matter, and that the enemy is not a single group, but a network of extremists and their state and non-state supporters. The president declared that our war aim is to defeat terrorism as a threat to our way of life as a free and open society. That was the theme of his speech that he delivered on September 20th to the joint session of Congress in 2001. Now, we couldn't achieve that aim. We couldn't maintain a free and open society with a solely defensive strategy. To preserve civil liberties, the president had to adopt a strategy of disrupting terrorist networks abroad, where they do much of their planning, recruiting, and training. He had to adopt a strategy of initiative and offense. I, at the time, put it this way. The president decided that in dealing with the terrorists, he had to change the way we live or change the way they live. Now, when we get to the questions and answers, I'll be happy to talk with you about how these ideas tied into the Bush administration's decisions, debates and decisions on strategy for Afghanistan, Iraq, and elsewhere. We can get into any questions that you have about the various charges and alleged scandals that are connected with the Bush administration, with my office in particular. Bush lied, people died, the allegations about manipulation of intelligence, post-war planning for the Iraq War, anything else that you want to raise. But before we get to the questions and answers, I'd like to tee up one of the most controversial issues in the fight against Islamist totalitarianism, and that's the issue of detention and interrogation policies. And here I'd like to make two main points. I'm going to make them in summary fashion, but I'd welcome questions and challenges so that we have a fuller discussion about any that are of particular interest to you. First of all, it's become common to hear critics of President Bush say that his administration ordered or at least condoned the torture of detainees. It's a nasty calumny. It's not true. When the issue of the legal status of the detainees captured in Afghanistan first arose in early 2002, the president made the following decisions. He resolved a debate about the applicability of the Geneva Convention to the U.S. conflict with the Taliban by declaring that it did apply. He determined that the Taliban detainees were nevertheless not entitled to POW status, prisoner of war status, because they failed to fulfill the conditions for that status spelled out in the Geneva Convention. And President Bush directed that all detainees, the al-Qaeda detainees whom he said were not covered by the Geneva Conventions at all, and the Taliban detainees who were, that all detainees be treated lawfully and humanely. And lawfully meant no torture, because we have a treaty obligation and a statute prohibiting torture. All of the decisions and guidance given down the chain of command were under the general order of the president that all detainees must be treated lawfully and humanely. Now, waterboarding was never approved for use by the military or DOD personnel, and my understanding is that it was never used by anyone in the department. We now all know from declassified documents that the Justice Department studied the matter and concluded that with restrictions, waterboarding could be used by the CIA. And the CIA director, Mike Hayden, publicly told Congress that waterboarding was used on only 3 of the most important detainees. Now, as this is a forum in a law school, I'll make a legal observation. It's clear that the administration took seriously the issue of whether waterboarding is legal. The matter was referred to the proper office in the government, the Office of Legal Counsel in the Justice Department. It was asked for its opinion. It answered in writing. Critics have a right now to take issue with the conclusions of the Office of Legal Counsel and its analysis, and the new administration can come to a different legal conclusion if it wants to, and it has. And the president has declared that, in his view, waterboarding is illegal, is torture. But it is not just or responsible to attack officials as criminal practitioners or supporters of torture if those officials were relying on guidance properly provided by the Office of Legal Counsel and operating within that guidance. Now, the second common allegation I want to address is that the leadership of the Rumsfeld Defense Department was disrespectful or even contemptuous of the Geneva Convention, and that the leadership's bad attitude poisoned the atmosphere within the department and led to abuses of detainees at Abu Ghraib and elsewhere. That's not only not true, but the opposite was the case. I'll tell you how the Geneva Convention issue arose and how it was handled. The president was presented with the question, this was in December, January of 2001, 2002, when we got our first set of detainees in Afghanistan. And the question arose as to the legal status of the detainees. And the particular question that came up was whether the Geneva Convention applied to our conflict with the Taliban. Now, there was a general view that the Geneva Convention did not apply to our worldwide conflict with al-Qaeda, because the convention itself says that it applies to conflicts between or among the parties to the convention. And so it was quite clear that al-Qaeda is not a state, it's not a party, and the general view was that al-Qaeda was not covered by the convention. I know that the Supreme Court later addressed that in a different way. We could talk about that if you want to, but I can tell you that nobody made the argument that al-Qaeda was covered by the Geneva Convention at the time. But there was a question of whether the Geneva Convention applied to our conflict with the Taliban. The Department of Justice and some others argued that the president has the flexibility not to apply the Geneva Convention to our conflict with the Taliban, even though Afghanistan is a party to the Geneva Conventions. And the argument that Justice made was that Afghanistan is not really a state. One could say that Afghanistan is not really a state, but a failed state. And the Taliban is not really a government, it's more like a criminal gang. Now, when this issue came up and was going to be discussed at a National Security Council meeting in early February of 2002, General Dick Myers, who was the chairman of the Joint Chiefs of Staff, and I went in to brief Secretary Rumsfeld on this issue. And General Myers and I wound up agreeing on this, I think pretty much to his surprise. And what we did is we advised Secretary Rumsfeld to oppose the argument that these lawyers from the Justice Department were bringing forward. We said, and we used this language, we said the United States should not be straining to weasel out of the Geneva Convention. I started with Secretary Rumsfeld by observing, Secretary Rumsfeld is a stickler for law. He was an Eagle Scout, and he takes that very seriously. And arguments about what is lawful and not lawful were showstoppers with him. So I started off by saying, Mr. Secretary, compliance with the Geneva Convention is not optional. The Geneva Convention is law. Right? It's not like a UN General Assembly resolution. It's not a recommendation. It's a treaty in force. And under our Constitution, statutes and treaties in force together are the supreme law of the land. And what I'd like to do is read to you from a memo that General Myers and I prepared for Secretary Rumsfeld for the meeting with the President that decided this issue. And this is basically the memo that summarized the argument that we made to the Secretary orally when we met with him a day or two before this I believe it was the February 4th, 2002 National Security Council meeting. And it reads as follows. There's a section called DOD, Department of Defense, Interest in the Geneva Convention. We said it's important that the President appreciate DOD's interest in the convention. The convention is a good treaty. One could quibble about details, but the convention is a sensible document that requires its parties to treat prisoners of war the way we want our captured military personnel treated. U.S. armed forces are trained to treat captured enemy forces according to the convention. This training is an essential element of U.S. military culture. It is morally important, crucial to U.S. morale. It is also practically important, for it makes U.S. forces the gold standard in the world, facilitating our winning cooperation from other countries. U.S. forces are more likely to benefit from the convention's protections if the convention is applied universally. Highly dangerous if countries make application of convention hinge on subjective or moral judgments as to the quality or decency of the enemy's government. That's why it's dangerous to say that U.S. is not legally required to apply the convention to the Taliban as the illegitimate government of a failed state. A pro-convention position reinforces the U.S. government's key themes in the war on terrorism. The essence of the convention is the distinction between soldiers and civilians, i.e. between combatants and non-combatants. Terrorists are reprehensible precisely because they negate that distinction by purposefully targeting civilians. The convention aims to protect civilians by requiring soldiers to wear uniforms and otherwise distinguish themselves from civilians. The convention creates an incentive system for good behavior. The key incentive is that soldiers who play by the rules get POW status if they are captured. The US can apply the convention to the Taliban and al-Qaeda detainees as a matter of policy without having to give them POW status because none of the detainees remaining in US hands played by the rules. In sum, US public position on this issue should stress humane treatment for all detainees. US is applying the convention. All detainees are getting the treatment they are or would be entitled to under the convention. US supports the convention and promotes universal respect for it. End of quote. Now, this was the position that, as I said, I developed in writing with General Myers. We presented it to Secretary Rumsfeld. He had us present it to the President. And as noted, the President decided that the Geneva Convention did apply to our conflict with the Taliban. It is recklessly false to assert that the leadership of the Defense Department was disrespectful of the Geneva Convention. I hope that this talk has caused you to doubt some of the conventional wisdom about the thoughts and actions of the Bush administration regarding respect for law and the trade-offs between public safety and civil liberties. Now, I realize the topics that I've touched on are highly controversial. Reasonable people differ about them. Every sentence that I've presented to you can be challenged, and I hope that you will challenge a number of them. But the differences can be debated civilly and with proper care for the facts. And I think it's extremely unfortunate that much of the public discussion is both uncivil and at odds with the facts. A point about the public debate that I'd like to close with is a point that I closed my book, War and Decision, with. I talk about the public debate over the extremely intense controversies regarding Iraq and the war on terrorism in general. And I'd like to conclude, as I conclude the book, with these few thoughts. Is the debate in America as serious and civil? Ooh. It's 6 p.m. Somebody turns out the light at 6 p.m. Is the debate in America as serious and civil as it should be? Is it worthy of the stakes in this war, worthy of the reason we are fighting to preserve the free and open nature of our society? And is it worthy of the men and women in our armed forces who are bearing the brunt of this fight? Our military forces are performing skillfully and courageously. Their sacrifices are securing our lives and liberty. We owe them gratitude, and we honor them when we aspire to fulfill our duties as citizens at home as nobly as they fulfill their duties as warriors abroad. I look forward to your comments and questions.
I've heard an interesting critique that's the opposite of the conventional one, that says that the problem with the Bush administration's lawyering was that it was hyper-legalistic, which led to a perverse undermining of sort of general international law because of a hyper-legalism. So it led him to unsign the ICC rather than deal with the waffle that President Clinton had done. And it led him to not launch a international, next convention, next round of Geneva Conventions to update the laws of war, of armed conflict, to reflect the new kinds of conflicts we're facing, because to do so would be to suggest that the law doesn't apply, and our lawyers told us we had found a way to do everything we needed to do within the existing law. In other words, it's a hyper-legalism that had the effect. And there was a number of folks inside, as you know, Goldsmith and the NSC lawyers, who thought we missed an opportunity to have a broader debate that might have created a more sure and lasting foundation of public support for a new sort of rule of law embrace.
Well, I would take issue with some of what you said, but I think the key point you're making, I think, has validity. I think that there was a problem with the legal analyses, with some of the legal analyses that were used in connection with detention and interrogation issues, and there was a kind of artificiality. Those of you who are interested in political science should be particularly interested in the problem that I saw when these issues were worked. They were largely worked within the administration through interagency meetings of lawyers only. And I mean, this is something that happens. It happens in various administrations. When it was happening, I remember I talked to Steve Hadley about this. He's also a lawyer who was not functioning as a lawyer in the government. I was not functioning as a lawyer in the government. We both had policy positions. But I talked with him about it and said, and he agreed, but it happened anyway. I said, it's not a good thing for lawyers to meet in interagency forums without their clients. We were dealing here, when you talk about things like detention and interrogation, these are extremely important, sensitive, difficult questions that have major political implications and international diplomatic implications, and therefore strategic implications. The way the administration handled this is they largely turned the thing over with after this meeting that I described, this National Security Council meeting, February 4, 2002, before that and then after that, almost all of the interagency meetings dealing with these subjects were almost exclusively lawyers. And I mean, I've got nothing against lawyers. Some of my best friends are lawyers. I was trained as a lawyer. I practice as a lawyer. I mean, I'm not prejudiced against lawyers, but the fact is, lawyers brought to those meetings a set of considerations appropriate for lawyers. That set of considerations was much narrower than the full set of considerations that should have been brought to questions of this kind. I'll give you one example to support the thesis of your question. There was a question that came up whether we should seek legislation from Congress creating a statutory framework for our detention and interrogation policies for the war on terrorism. I mean, it was clear to everybody that we were using models from the Geneva Convention and prior law that were premised on, assumptions about war that really related more to conventional war or even conventional types of irregular war than they were to the particular global conflict with Al-Qaeda and its terrorist network that we were facing. So, I mean, we all were uncomfortable that the law didn't quite fit neatly, and we needed to, address things that were not directly addressed by the laws. And so the argument was, we actually had a suggestion from some people in the Congress saying, we will pass legislation that will give a framework to what you're doing. It's not that the people on the Hill were against what we were doing or wanted to change it necessarily, but they wanted to give it a framework. And since one of the suggestions came to me, I requested a meeting with the lawyers who were working on this subject. And I remember Steve Hadley convened the meeting. And I said, I think there'd be a lot to be said. I mean, we're getting criticized that everything that we're doing in this area is under the president's commander-in-chief authority. And that means that there are not the kinds of checks and balances that exist when you have a piece of legislation, and we have people on the Hill who are willing to pass constructive legislation on the subject. Well, there were people in the room who were extremely emphatic that we should not ask Congress for legislation on the subject because the president had the right to do this. Detention and interrogation are military operations. They are under the commander-in-chief, and you don't want Congress legislating on military operations, how to do military operations. Now, I understand that argument. That's not an anti-democratic argument. That's an argument that you can make. I mean, there's some basis for it. It's not ridiculous. But it's an argument that looks, in my opinion, rather narrowly at the relevant considerations here. And the upshot was that we passed on the offer at that time to get legislative help on this issue. And a year later, when the whole issue of detention and interrogation had just completely blown up in the face of the administration over and over again at enormous cost to the administration's credibility and our strategy and everything. At that point, we got the legislation. We got legislation that was much less favorable than we would have gotten had we asked for it a year before. It was a gigantic mistake to do all of this innovative, difficult, morally and conceptually difficult work on interrogation and detention policy without going to Congress earlier. Again, the lawyers had a perfectly okay legal argument as far as it went. But the idea that the interagency deliberations were limited to lawyers was a big mistake. And there were a number of other examples like that one could do. So as I said, I think there's some validity to your to the point, although, as I said, I might take issue with some of it. I'm not a fan of the International Criminal Court. I mean, just in a word, the problem with the International Criminal Court is that a crucial part of our civil liberties is the idea of checks and balances applying throughout our system, including on prosecutors, who are ultimately politically accountable. Prosecutors in the United States, in almost all cases, are either elected or they work for people who are elected. And if prosecutors misbehave, and I think at Duke you know something about prosecutors who misbehave, if prosecutors misbehave, there should be some check, some accountability, some way of getting at them. Because, I mean, when you think about the early history of civil liberties in the Anglo-Saxon civilization, one of the main things that people were worried about who wanted to secure civil liberties was precisely securing them against prosecutors who might be abusing their power. The International Criminal Court has prosecutors who, for all practical purposes, report to no one. And that, among other things, is a reason why Americans who are jealous of their civil liberties, I think, should be highly allergic to that institution, that treaty. Sir?
Your conversation with Peter Rodman in the airplane coming home is very reassuring, and as a historian of American war making, I would agree with it and have written so. But it's puzzling to me why, if that was the case, and if the president was so focused on a freedom agenda, he would assert a position and act upon a position on the habeas corpus rule in the case of Mr. Hamdan and Mr. Padilla, and make the arguments in court about the inherent power of the president over American citizens, when, as we know in the Constitutional Convention, the framers of the Constitution were so concerned about the expansion of executive power in wartime, particularly as a threat to liberty. So could you explain that anomaly? I assume the Department of Defense supported the Department of Justice's and the White House's position on the president's inherent power in habeas corpus.
That was an issue that I did not that I didn't work on in the government. That didn't come to the policy office, but I'm familiar with the issue. I consider that a much harder question than the question of whether we should have gone for a legislative framework. My understanding, and I'm no scholar on habeas corpus, but my understanding is that never before in U.S. history had anybody suggested that detainees captured in war have the right to appeal to American courts with a writ of habeas corpus. And I guess the main point that I was trying to make with my presentation, as I said, you could talk about habeas corpus, you could talk about the Patriot Act, you could talk about 50 or 1,000 specific cases where there are issues of civil liberties that were traded off against considerations of public safety. And I'm not equipped even to address all of them and argue that the balance was struck exactly in the right way, or might there have been a better way to do it. I tend to think that the administration view that habeas corpus doesn't and shouldn't apply to detainees in war is correct. I mean, I understand that the Supreme Court found otherwise, but it was my understanding is that was a split decision. And it's one of those things that reasonable people can disagree about. But I guess the overall point that I was trying to make was simply that these things were, in fact, seriously considered. You can argue whether a particular case was resolved correctly, but the common criticism, which I read over and over again even now, even though passions have cooled somewhat from where they were a few years ago, even now one commonly reads a criticism of the administration that's essentially a cartoon picture of Vice President Cheney and others sitting around rubbing their hands saying, thank God we got attacked on 9/11 so that we can curtail American civil liberties. I mean, it's just important to understand that that's a ridiculous distortion of the nature of the deliberations within the administration. And as I said, I mean, I've heard lots of arguments that certain things the administration did, it didn't do right, or it could have done better. And I'm sure that's true in a lot of cases. But what I hope you will take away is the idea that there were serious people, seriously interested in the Constitution, who were trying to strike the right balance under the circumstances. And everybody can be second-guessed, and things can always be done better. But it's important for people's confidence in the government to understand that these things were in fact taken seriously, and people understood the necessity to make these trade-offs, and people understood that they were trade-offs. That we approached these subjects from the point of view that I said that it was reflected in that quote by John Stuart Mill. We should have as much civil liberty as we possibly can, consistent with public safety. And part of the reason we wanted to fight the terrorist threat so aggressively was to keep the level of public safety up so that we could preserve our civil liberties. Sir?
Bruce Smith on public policy. I haven't read your book yet, so I assume you may have addressed these issues in the book, but I'm wondering if we could get you to reflect on, what contribution you made as a public servant of which you're most proud, and on the other hand, what mistake you made, which on reflection, you would have done something otherwise to solve, and what you learned from it.
I do try to address those questions in the book. I would say the general thing of which I am most proud was having been part of a team of people who crafted a strategy whose purpose was something that was extremely ambitious and unprecedented, which was the president saying after 9/11, that our mission as a government was not just find out who did it and punish them, which was basically the approach that we took after terrorist attacks for the preceding decades. The president said something unprecedented and very large after 9/11. He said, the purpose of our response to 9/11 is to prevent the next attack. Now, no president of the United States had ever responded to a terrorist attack before with such an ambitious goal. And the administration put together a comprehensive, global, strategic approach, by no means flawless, but it was a serious effort to do everything reasonable that we could to disrupt the network of Islamist extremist groups and their state supporters. And here we are more than 8 years after 9/11, and we have not had the follow-on attack that it was reasonable to suppose was coming after 9/11. I mean, again, when you talk about casting your minds back, as I suggested at the beginning, I can't imagine that anybody here would have given anything but extremely long odds to the idea if I had asked you on September 12th, 2001, what chance would you give that 8 years from now we're going to find that we have not suffered another attack? And I certainly think that the strategy that was developed for hitting various terrorist groups and state supporters and disrupting the network financially and by law enforcement and diplomatically and militarily and in every way that we could, that strategy contributed to keeping the country safe. And I think that's a proper source of pride. On the regret side, what I talk about in my book, there are a number of regrets about Iraq from the point of view of regrets of what the government did and regrets about what I and my office did. I mean, I think that one of the things that I really regret is we did some work on the issue of civil disorder following the overthrow of Saddam. And we identified in a memo before the war the danger of civil disorder and looked at precedents like in Panama and elsewhere where we said military victory can become defeat if you don't pay attention to preserving order after the removal of the government. And it is a major source of regret that we didn't do more to drive that point home. I think that we paid the country. The United States paid a big price for the fact that CENTCOM was not as focused on that problem as they should have been, and I wish we had done more in that area to highlight that issue and bring it up to the level of the secretary and have him raise it with the commander, and I think that's a big regret. I think on the war in general in Iraq. My view is the single biggest mistake we made was setting up a protracted occupation government. And if that's something that people want to talk about more, I'll be happy to talk about that more with you. Please.
Yes, my name is Jason Afan. I'm a third-year student at the law school here. And I want to applaud you for quoting Justice Jackson, who did say the Constitution is not a suicide pact. But he was also a courageous justice who stood up for civil liberties in wartime when people were parrying the same sorts of arguments and the same mindset that you set forth at the beginning of your talk. And he dissented in Korematsu, the famous Japanese internment case. And he also wrote a book on FDR in which he offered, and you asked us at the beginning to think about the way we would have made decisions. And in this book, he said the best thing a government advisor can do is offer a sense of detachment and not only push your own political objectives, but to evaluate the best evidence and reach a conclusion inductively. And what I think is, I think you ran your office with a different mindset. And I think Exhibit A would be a PowerPoint briefing you delivered entitled Iraq and Al-Qaeda Making the Case. And one slide said, intelligence indicates cooperation in all categories, a mature symbiotic relationship. And that disregarded the best evidence from the intelligence community at the time. The Department of Defense Office of Inspector General concluded that your actions were inappropriate. So I would like to ask you, what can we do to restore Justice Jackson's spirit of detachment in government decision-making and ensure that intelligence failures at the highest level don't lead us into another misguided war?
Okay, well, one thing we can do is try to get the facts as straight as we can. And you didn't have the facts quite right about what you were describing. For example, the name of that briefing was wrong. You quoted it wrong. And it was an important point because the name of that briefing was cited as was cited as an example of kind of prejudice in the briefing. I mean, I wonder how much we want to get into some of these details. Let me see if I could do this very briefly. What you're referring to and what the DoD Inspector General looked at was, also it was not a briefing that I gave. There were people in my office who were working on the general issue of the strategy for the war on terrorism. In the course of their work, they came upon some intelligence from the mid-90s, produced by the intelligence community, about Iraq al-Qaeda connections. The CIA in 2002 was working on reports on the Iraq al-Qaeda relationship. And the theory that predominated among CIA analysts was the secular Ba'athist regime of Saddam Hussein would not deal with the religious extremists of al-Qaeda because of the ideological differences between them. Many people, myself included, were not very impressed by that argument because we knew a number of examples in history where ideological foes cooperated for strategic reasons. So the notion that ideological foes couldn't cooperate against us, seemed to prove, for example, that the Nazis and the Soviets didn't cooperate. Well, they were ideological foes, but of course they cooperated. We know that. So we were not very impressed by that argument. And what was happening in the course of 2002, when the intelligence community was working on this, people in my office criticized the CIA and said that the intelligence community was filtering and suppressing its own information that was inconsistent with its own theory that these parties couldn't cooperate. And we said it's wrong for intelligence people to shade their intelligence to support their own preconceptions. This is not professional. Now, when one of the people and I do tell this story in some detail in my book, one of the people in my office who worked on this called somebody at the Defense Intelligence Agency and said, why are you suppressing such and such an information in your new report on Iraq and al-Qaeda? And the analyst told her, if we put that in the report, it would only strengthen the hand of Wolfowitz. And the person in my office said, that is a completely improper answer. That's not professional. So people in my office were quarreling with people in the intelligence community. And naturally, the people in the intelligence community said, well, you're not really interested in criticizing us for lack of professionalism. You just want us to do what you want to do. Okay, I mean, you expect that kind of response. Now, what ultimately happened was there was this debate. The debate got resolved when George Tenet, in October 2002, issued a letter, a public letter, unclassified. It's available on the internet. Any of you can get it. It's October 7th, 2002, I believe, to the chairman of the Senate Intelligence Committee, Senator Graham from Florida. And in that letter, he said, here's what we know about the Iraq al-Qaeda relationship, and he listed it. And that basically became what everybody in the administration stood on from that point forward. And he explained there was a relationship. It wasn't enormously significant, but it wasn't nothing. And he laid it out. Now, a very strange, in the course of all of these controversies, some members of Congress asked the DOD Inspector General to look into my office and the criticism that we made of the intelligence community and to examine whether anything we did was unlawful, unauthorized, or inappropriate. And they did an investigation for like a year and a half and concluded that everything that we did was authorized and everything that we did was lawful. And yet they said the criticism that we made and presented to some people in the White House of the CIA was inappropriate. And the Inspector General was then asked by the Senate Armed Services Committee, why was it inappropriate? And he said, well, it undercut the intelligence community and it didn't reflect the best intelligence. We said, well, it's a criticism of the intelligence. Of course it didn't. We didn't. I really don't understand. Then the Inspector General was the acting Inspector General was asked, was the criticism valid? And the Inspector General said, and this is available, I believe, also on the internet, the video of this. The Inspector General said, we didn't look at that. So what he said was the fact of criticism was inappropriate. And I have to tell you, with all due respect to the DOD Inspector General, I don't agree with that. And I'm willing to disagree with him till the cows come home over that issue. I think that policy people have a perfect right to criticize, and the notion that you would call the criticism inappropriate when you haven't even examined, and the DOD Inspector General didn't examine it because they're not even qualified to judge whether the criticism is valid, so they didn't even attempt it. But the notion that without attempting it, you say that the criticism undercuts the community, we all know that our intelligence community, brave people, hardworking people though they are, is capable of mistakes. Some of the mistakes are rather notorious. Do we want to establish the principle that policy people criticizing the CIA is inherently inappropriate even if the criticism is valid? Anyway, I don't buy that. That's what that's about. And so with all due respect, I think that we did bring the spirit of Justice Jackson to our work as you described, but I think there's a lot of misunderstanding about what we did.
I was wondering if you could address the intelligence mistakes more broadly, specifically when General Powell went before the UN and presented that whole presentation with the posters, the PowerPoint, and everything. It turns out that most of that intelligence was either highly tenuous or just turned out to be true. I'm just wondering what type of environment led to that evidence being used so publicly, and how could there be such a breakdown?
Okay, well, there's several things there. First of all, what Secretary Powell did in preparing for the UN presentation, he's talked about often. He basically eliminated White House and DOD people from the process. He took a small team of people. He went to Langley. He spent several days. He worked shoulder to shoulder with the director of the CIA, George Tenet, and that's why he had him sitting, if you remember the television show, it's pretty unusual. He's making a presentation to the UN Security Council and he has the director of CIA sitting over his shoulder, in the camera shot. I think there are a number of criticisms that one can make about that presentation. There were people in the government who advised Secretary Powell to look at the broad rationale for military action against Iraq. The rationale laid out, for example, in the congressional resolution authorizing force, which has, I don't remember the exact number, 20 or 30 key items listed that are part of the rationale for military action. Secretary Powell chose to downplay other aspects of the case against Saddam and to play up the WMD aspect. The reason being, he was at the UN, and the main thing that the UN was focused on was weapons inspection. So he was kind of playing to his audience by focusing on the weapons issue. A number of us said, that's a mistake. First of all, you're relying on intelligence, and some of us said, whenever you're relying on intelligence, you should be skeptical. You know, and as you could see in my book, there was a memo that Secretary Rumsfeld prepared about things that could go wrong in the event of war, and one of the things was, it may turn out there's no WMD. Now, it's not that he believed that, but he just said, it's in the nature of intelligence that it could be wrong. Think about it. Well, Secretary Powell didn't think about that hard enough, and he gave excessive reliance on the WMD argument in that forum. But I would point out that if you look overall at what administration officials said, the President, Condi Rice, and Don Rumsfeld, and Secretary Powell, and others, in the run-up to the war, you do see a rather broad rationale, not an exclusive focus on WMD, but that presentation to the UN was very harmful. The other thing I would say is this, and I disagreed with a point that you made in your question. Almost everything Colin Powell said in that speech, including about WMD, was correct. There were two things that were wrong. One was that we would find chemical and biological weapons stockpiles in Iraq. Right? Now, he talked about, and the administration talked about, Saddam's chemical and biological weapons program, his history of use of chemical weapons against the Iranians and against his own Kurds. We talked about his intentions. When the war was over and a British, American, Australian group of intelligence analysts went to Iraq, they were called the Iraq Survey Group, they produced a report, which you can also download on the internet. It's referred to, the preliminary report was referred to as the K report, the final report is the Delfer report. And I would encourage anybody who's interested in this to look it up on the web and at least skim it. The final report is a 3-volume report, and it talks about what we actually found regarding Iraqi WMD. We found facilities, personnel, programs, materiel, intentions, where the CIA made a gigantic error, and it was gigantic, and I'm not belittling it, and it was enormously harmful. Where they made an error was they said we would also find stockpiles. What the Iraq Survey Group found was Saddam had put himself in a position where he could have biological weapons in 3 to 5 weeks. But he chose not to maintain stockpiles. The CIA got that wrong. That was one of the things they got wrong, the chemical and biological weapons stockpiles. The second thing they got wrong, according to the Iraq Survey Group report, was he said that the nuclear program in Iraq was active, which is what the CIA believed. And what the Iraq Survey Group found was that the nuclear program was essentially in a state of suspended animation, that it was not active. That Saddam did maintain, what the Iraq Survey Group said is the long pole in the tent of the nuclear program is trained technicians. Saddam had trained technicians and he preserved them as a team. He did not have them working elsewhere. He had them ready to go because he intended to have WMD and an active nuclear weapons program as soon as he got out from under sanctions. But until he got the UN sanctions removed, he had the nuclear program in a state of suspended animation. So the Iraq Survey Group concluded that the CIA's saying that the program was active was wrong. Those are the two errors, the stockpiles and the degree of activeness of the nuclear program. But on the issue of whether he represented a chemical and biological weapons threat, and whether he had programs, and whether he had intentions, and whether he could produce the stuff literally in 3 to 5 weeks, the Iraq Survey Group found all that too. And so you should just be, I think, quite careful. Part of the problem is when that report came out from the Iraq Survey Group, it was 3 inches thick. It was released by the CIA without even a 1-page summary of key findings. It was simply handed to journalists. George Tenet boasts about this in his book, that he kept the whole report out of the hands of anybody in the administration, the White House, or anybody else. Well, it's fine to keep it out of the hands of any political people so they don't taint the substance of the report. But when it comes to releasing it to the press, if you hand 3 inches of material to journalists who, like for the wire services, have to file a story within an hour or 2, and you haven't even told them what the key findings in the report are, what are they going to do? They're going to do what they did. They ran stories, the headline of which was "No WMD Found," leading virtually everybody around the world to conclude that the entire worry about WMD was groundless, which is not at all what the report says. But there we are. Anyway, this is something that, again, the facts on these things are very different from the conventional thinking about it. And I hope if, even if you forget every specific thing that I've said here, that what you take away is a degree of skepticism about what you think you know about these highly controversial subjects.
One of the most interesting things about the Bush administration is the sort of approach they took to...
I don't know if people can hear.
Sorry.
You wanna...
One of the most interesting things, I think, about the Bush administration is how they approached interpreting the executive power. And I was wondering if you could comment on the rationale in making policy decisions about military tribunals, for example, and altering their structure when there was already a set framework laid out under the UCMJ. Similarly, if you care to comment, how like the warrantless wiretapping program existed and how the administration thought they could legally get around like FISA courts.
The latter point I really know just about nothing about, so if you don't mind, I'll pass on that. I know a little bit more about the military commissions, although, again, that was not handled by the policy office, it was handled by the general counsel's office. And I do know that what Secretary Rumsfeld, together with other people in the administration, did was look at the question of whether we can use ordinary Article III courts, the ordinary judicial system, for the detainees, and what would be the problems with using them, and whether we can use the Uniform Code of Military Justice and the existing military court system. And they came to the conclusion, and I don't have it all at my fingertips, but I mean, there was serious analysis done saying the rules of evidence, the issues of what you have to disclose to a defendant, and security issues, all argued that we would not be able to use those courts, and that a special tribunal would need to be set up. And then there were precedents, as you know, in American history in various wars, including what Franklin Roosevelt did in World War II in setting up military commissions. And so the decision was made to set up military commissions. And what I remember, I mean, I wasn't playing, but I was in the room when it was being discussed on a number of occasions. And I remember what the secretary was saying in his discussions with the general counsel about this is, we need to have a system that doesn't provide all of the protections that criminal defendants in American courts get, or the military court defendants get, but we have to provide enough protections that people will consider this fundamentally fair. I mean, as any of you who study comparative law know, there are lots of variations throughout the civilized world on how people handle judicial procedures. There's not one way. And so the question was, can you devise something that, again, strikes balances properly so that you take care of the security considerations, but also take care of the fundamental fairness considerations? And as this was being devised, I know that the general counsel at the Pentagon was working with Secretary Rumsfeld with a panel of outside advisors, including very prominent Democratic, former officials from Democratic administrations. And he specifically wanted to make sure that the concept of fundamental fairness was run by eminent lawyers, former FBI directors, former judges, former cabinet officials, former White House counsel. I mean, a really eminent group of people, bipartisan, to make sure that he was doing it right. Now, again, I wouldn't defend everything he did. I don't even know everything he did. But the message that I want to get across is nobody should think this was done lightly or negligently or without solemn respect for constitutional principles. And, it can be criticized, and that's fine, but it should be criticized with some understanding of the attitudes that were brought to the work.
It seems that in recent years, the role of contractors in both defense and intelligence operations has increased significantly. What do you see the future role, how do you see the future role for contractors, especially given the questionable application of Geneva Conventions to their military-style operations?
Yeah, that's a tough problem because there are very severe restraints on the government regarding personnel. And if you need to get a number of highly specialized, trained people to do specific tasks, you can't just do a dragnet through the government and find people lying around who know how to train police forces or do security work. And yet there are a lot of alumni of the intelligence and military, the U.S. intelligence and military services, and contractors bring those people together and make them available quickly on a surge basis for as long as you need them, and then you can get rid of them when you don't need them. Whereas when you hire people for the government, because of all the civil service regulations and the like, it's very hard to hire them and you can't get rid of them afterward. And they don't necessarily have the skills. And then anyway, there is a reason why contractors are used. This is another area that I'm not at all an expert in. It wasn't, this was it was just, outside of my field, but it is clear to me that various things can be done to improve the situation. And I know that Congress is looking at it, and that's fine. And I'd be all in favor of making the kinds of changes where you build in the necessary flexibility so that you obviate the urge of commanders or of ambassadors to look to contractors for certain jobs, and that's fine. And you're quite right that when you bring contractors in, you're you're solving some problems, but you're creating others. And the whole issue of how the law applies to them and what rules govern them and all that, those are tough problems. But there is a reason why it happens. And if you can ease up on maybe on the personnel stuff, you might be able to do without dependence on the contractors to the same extent that we now have.
Alex Downs from the Department of Political Science. So you rightly pointed out early on that President Bush stated that all detainees had to be treated lawfully and humanely. Nevertheless, some detainees were treated inhumanely, and others were rendered to places where they were treated inhumanely, and it was known beforehand that they would be treated inhumanely. In some cases, they were sent there because they were to be treated inhumanely. So how does the practice of extraordinary rendition fit with your description of the legality of the Bush administration's practices in war and terror?
That's an intelligence operation. The rendition was a practice that the CIA was involved in. I don't know enough about the details to know if all of the things you said that were, you put forward as facts are facts. In other words, you said things like they transferred to countries knowing that the people would be abused. I don't know that that's true. I'm not denying that it's true. I'm just saying I don't know it. And, intelligence operations were not, they were quite tightly contained. They were not discussed generally. So, what the CIA knew or didn't know, I don't know. I do know that the work that my office did regarding policy for the Defense Department regarding detainees was governed by our understanding of the key guidelines provided by the President. And we interpreted and said so explicitly in our discussions that when the President said lawful, that meant no torture, because we understood that torture was unlawful. And when he said humane, that was something that was going to have to be worked out and defined. Part of the problem was the President set a standard. This is not unusual, as any of you who study admin law know. Standards get set, and then people in the agencies who then do operations basically fill in and define in greater specificity the standards. And when the President set the standard of humane, he didn't publish a book. He just said humane treatment, and then the people were going to have to work with that as a standard. If you read the documents that the Justice Department declassified over the years, including recently under the Obama administration, and you actually read them rather than just read some characterizations of them, what you will see is even the documents that get the most criticism and are considered the most outrageous are detailed, agonized discussions about how to try to bring pressure to bear on detainees so that they will reveal what they know so that we can head off attacks, and yet don't really hurt them too much and set up safeguards. And if you actually read the documents, you can picture the people sitting in their offices wrestling with these horrendous problems. And I was in the Reagan administration during the Cold War, and I know that when we were worried about our main military threat during the Cold War, we had intelligence that you could get from satellites. If we were worried about the Soviets launching the Red Army westward across Germany, we could look from satellites to see whether they were mobilizing the divisions in the Western Military District. In the war on terrorism, the only way we could know what the terrorists were planning when they were moving was learning what was inside their heads. You cannot overstate the importance, and especially after 9/11 when people were agitated. This is why I was telling you, cast your mind back. People were agitated. We expected follow-on attacks. We had captured a few people, and learning what they had in their heads could be the key to heading off an attack that could kill many thousands of people. And people were motivated. They were driven. We have to learn what these people know. And many of the people that we were interrogating were themselves trained in resistance techniques. And so the dilemma was, how do you bring effective pressure to bear, but still stay within the bounds of law and humane treatment? And I would encourage you, I didn't have anything to do with the writing of those Justice Department memos, but read them. Nobody can come away from reading those memos and say, oh, this was a bunch of bloodthirsty maniacs, looking to torture people. Those memos are so agonized and so carefully written and so full of qualifications. And again, you can argue that they came to some wrong conclusions. To tell you the truth, when I read them recently when they got declassified, I thought they came to some wrong conclusions. I would have done them in some cases differently. But so what? The people who were doing them were clearly making a serious humane effort to try to solve a really tough problem. And we still have that problem. And as a matter of fact, we have that problem now in some ways in aggravated form, because all of the rhetoric and everything that's been done to to blast the people who were involved in this analysis is simply going to make any interrogator in the future reluctant to ask, any kind of, conduct any kind of tough interrogation, even a lawful and humane tough interrogation. I mean, think of what goes on in American police stations every day. You cannot do at Gitmo now stuff that is standard in American police stations across America. And and everybody could say, well, I feel good about myself that we're not doing it. And you can feel good about yourself until the next major terrorist attack occurs. And you've got thousands of dead people who might have been spared had we had tougher interrogations. I mean, these are really tough problems. And I think that a lot of people have approached it from an either political point of view or a moralizing point of view without the right kind of understanding of the nature of the people doing the work and what they were trying to accomplish, and the fact that you in fact, I would suppose, have much more common ground with them than the divisiveness of the public debate would suggest.
We have time for one more.
You mentioned earlier about your pride in the Bush administration's sort of robust plan in foreign policy. Do you believe that American power has diminished because of this confrontational plan opposed to our more accommodating plans in the past administrations, say, during the middle of the Cold War?
I think this issue of accommodating versus unfriendly, it's usually discussed in terms of unilateralism. I think a lot of that debate is based on a misunderstanding of what we actually did. We, in fact, understood right from the beginning that the nature of this problem, of, the set of problems of Islamist extremism, terrorism, proliferation, and the like, the nature of those problems is such that not only is there no military solution to the problem, it requires military, diplomatic, intelligence, law enforcement, financial, all kinds of actions, far beyond. That's, by the way, the reason that Secretary Rumsfeld, rather famously, didn't like the term war on terrorism. He said he doesn't like the term war on terrorism because it overemphasizes the military instrument. And in fact, to do this war, you need, as the administration put it, all instruments of national power, which is what the Obama administration refers to as whole of government solutions. Same concept. And we understood that not only does it require all instruments and not just the military instrument, but it requires cooperation with countries all around the world. I mean, one of the main things that my office, in developing the strategy documents for the war on terrorism, emphasized over and over again, is that there is a major strategic peculiarity in this war, and that is the dilemma: how do you fight a war against an enemy located in numerous countries with whom you're not at war? That was not a problem in the past. In the past, when we were at war, if you could identify the enemy, you could hit him. And we've got enemies in Yemen and Germany and Indonesia and Pakistan and other sovereign countries. And you can't just operate freely. Now, you look at a case like Pakistan, we decided we can operate a little more freely than in other places. At some point, you get it up to here. Right? But these are tough problems. I mean, we're trying to respect Pakistani sovereignty to some extent. But these other countries, we respect their sovereignty completely. How do you fight a war when your enemy is in places inside sovereign countries? The only way is through cooperation with those countries. We said that from the beginning, and we got attacked for being unilateralists. I mean, my view of unilateralism was always, only an idiot could be a unilateralist. Which is why our critics called us unilateralists. I mean, it was so obvious that if you were a unilateralist, you were an idiot. But I mean, nobody I know believed that the United States should operate unilaterally. And so this notion that we damaged ourselves by being unilateralists, and now that we have President Obama in, we're multilateralists, I don't buy that. I think there's actually a lot more continuity than all of that rhetoric suggests. And I think that you get a certain amount of cooperation from countries for various reasons. We actually got a lot in the Bush administration that people don't generally give us credit for, and we're getting a lot less in the Obama administration than some people had hoped for. And basically countries do what they do, based on whether they see that they're making common cause with us or not. And if they see common cause, they cooperate. Look, the French and the Germans, the main reason we got called unilateralists is when we go to war, for example, in Iraq, and we have the British with us, and we have the Poles with us, and we have 30 other countries. I don't remember exactly how many were in the coalition. We don't have Germany and France, therefore we're unilateralists. It's actually rather insulting to the 30 or so countries that went with us. But the interesting thing is, as bitter as our disagreements were with France and Germany over Iraq, while we were disagreeing with them on the Iraq issue, we were cooperating with them on law enforcement, intelligence cooperation, and other things in the war on terrorism. And it's just important for you to realize that so much of what you hear about these things is filtered through people who have a political interest in saying simple things. And very often, the realities are more complex. And if you really want to be an intelligent commentator, think of when you do your legal work, how deeply you dig into the facts. Well, if you don't dig equally deeply into the facts of these public policy issues, you run the serious risk of buying into conventional wisdom that's not correct. And as I said, that's kind of the main theme of this presentation, is just to be skeptical, including what I say. Go check everything out. But there really is value in digging more deeply, getting the facts, reading the whole documents. Don't just read the news account of the documents. And I think that over time, if you do that, you will find that your understanding of the Iraq War, of the war on terrorism in general, will be very different from the impression that you got just watching the television news or reading the newspapers. Thank you.